SBILL. Yes, so in CS Executive new syllabus, we have setting up of business entities, and very interestingly, we have labor laws. So many students ask, so why do we have labor laws? It was not there in SBEC old syllabus. Please understand that labor laws is going to be the future in terms of we have the new 4 codes. Few new 4 labor codes are there. So these new 4 labor codes will replace lot of the older labor laws, which is more than 40 to 50 different acts. So company secretaries will be the people who will also be able to do labor law work. So that is the reason of that. Having said that, I am Alok. I'm a practicing company secretary and I'll be teaching SBILL in the new syllabus CS Executive. And today in this class we will be having corporate entities. That is, what are the different type of corporate entities? So this is in your lesson number 2, and most importantly we'll try to understand the Companies Act, the Companies Incorporation rules, that is the regulatory framework for different corporate entities. So my first question to you before we even go ahead is that if you want to go from point A to point B, how will you go? You need to have a vehicle. You need to have a vehicle. If it is a short distance, the vehicle is called your legs. Your legs are the vehicle. You walk, that is a vehicle. You take a bicycle, that is a vehicle. Or you take a scooter, you take a car. If it is much further, you take a train, you take a bus, or you even can take a flight, that is, you can fly. So in general, to go to point A to point B, you need to have a vehicle, and that vehicle depends on what are the kind of activities you're doing and what is the distance, what is the cost. So many factors are there for this. Similarly, in business, to do business, you need a vehicle. How will you do business? How will you do business? So you can just do a business as a sole proprietor. You just start selling something, that is also a business. You can do a private limited company. You can do a LLP. So all these different things are nothing but business vehicles. So please remember that we need business vehicle. To go from one point to another point, you need a business vehicle. So for example, you have a car. I know this drawing of a car is not that great. It looks like your old ambassador. But anyway, so if this is a car, you need to have a car to go to point A to point B. So this car is what we call as a business vehicle. To do business, you need some form, you need some legal entity, and that legal entity is nothing but your proprietorship concern, your partnership firm, your company, your producer company, your nidhi company, public company, private company. All these are different types of companies which we call as business vehicles for you to do a business. So first come first, simple things. So you know what is a company? Company is people coming together and doing a business. So you need multiple people who come together. And if you see here, company has been defined as collection of many individuals united into one body under the special denomination having perpetual succession under the artificial form and vested by the policies of law with capacity of acting in several respect as an individual. So in simple, what are they trying to say? So when we say company, it can be a company which is doing business for small activities or bigger activities. In general, it is separate in the eyes of law. So let us have a look at that. So you have 3 people, okay, 3 people, they said that we want to start a company. So these 3 people start a company. So this company is what we call as the business vehicle to do the business, and this company is registered under the Companies Act 2013, and this company is separate from the people who start. So you have 3 people, their name is A, B and C for example. So A, B and C are separate individual people, so they are human beings, individuals, natural person. We call them as a natural person in the law. we call them as natural persons. Okay. So when we say company being a business vehicle, natural person will start an artificial person in the eyes of law. That is a company. So company is also a person, but company is something which can hold property and which will have perpetual succession. So even if A, B and C, they all will die. One day everybody is going to die. A, B and C is also going to die one day. Right? What happens to this company which they have started? The company will survive because in company law we say that perpetual succession. That means the company will always survive regardless of who is there. That means company is a separate person in the eyes of law. It is having a perpetual succession. It having its own individual identity, which we called as a artificial person. So how you in your personal name you have a PAN card, company will also have a PAN. Company is also a person. Company can do business, and that is the very basics about what is a company. So what are we trying to study? We are trying to study what is artificial person, what is perpetual succession. So I hope you got the idea. So artificial person is something which we create. Perpetual succession is something which will continue to exist whether the people are there or not. So in our ICSA book, there's a very nice sentence and a very nice case law which they have given, and that will give you an idea of perpetual succession. So during the war, I think England and Germany or something, some war was going on, and there was a company and all the members, all the shareholders, directors were having a meeting, and in the location where meeting was happening, there was a hydrogen bomb. So everybody died, but the company survived because company is an artificial person in the eyes of law. So they say in that case law, not even a hydrogen bomb can kill a company. That means company will survive because it is an artificial person. Even if all the members die, all the directors die, company still survives. Then you will tell, sir, how, sir, if everybody is died, how company will survive? See, as an entity, company is there, new members can come, court can order directors to be appointed, and you can carry on the business. But the fact is that company is artificial person and it cannot be killed. If that means can company never close, you can voluntarily close the company. Company can go into liquidation. Company can have winding up procedure and then liquidation. All that dissolution can happen. But if you just leave it, company will not die a natural death because it is a perpetual succession in the eyes of law. Then company can have property in its name. Company can have contracting obligations. So what is this contracting obligations? So company can enter into any contract. So how you and me enter into a contract? It could be something as simple as rental agreement. You take a house on rent, that is also a contract. That is also an agreement. You have certain conditions. What is the rent? How much you are going to pay? What is the yearly escalation? So like these kind of points will also be there. And anybody can file a case against company, and company can also file a case against others when the contractual obligations are not met or any other legal obligations are not met. So what are we trying to study? What are the different kinds of business entities? And in that, first we are going to company. So when I say business entity, okay, broadly speaking, first comes your sole proprietorship concern, okay. Then comes your partnership firm. See, one thing common in sole proprietorship and partnership, we are having unlimited liability. Then comes your limited liability partnership firm. So this is under the LLP Act of 2008. It is like a partnership firm, but it is having limited liability. As the name goes, limited liability partnership firm. It does not have unlimited liability like the proprietorship concern and the partnership firm. Then the most popular which we all have is company, which is company. So in company you have many different types. First you have, I go further, private limited company. Even before that, one person company. So there is only one person on the company. Private limited company, minimum 2 members will be there, shareholders, and maximum 200 members will be there. That is the shareholders, people who own the company. In one person company, as the name goes, there is only one owner. Only one person owns it. Minimum and maximum also one. As the name goes, one person company. You can't have more than that. But in a one person company, see, technically speaking, you can have more than one director. You can have more than one director, but not more than one member. So I'll come to that concept also. For in every company, when I say company, you have two decision making bodies, board of directors and shareholders, or what we call owners, members of the company. Okay, this is something which you have to be aware. So when I say board of directors, they are the management of the company. So they run the company on a day-to-day basis. They are the ones who conduct the board meetings, take the day-to-day decisions, hiring, firing, accounts, audit, all these responsibilities is the board of directors. We call management of the company. Owners of the company are the shareholders. Owners of the company are the shareholders. So this is in every company. This is the basic structure, and this is very unique to a company. You don't have any other body which is like this. You don't have any other body which is like this. Only in company you have. In proprietorship, in partnership, you don't have the separation of ownership and management. So this is called as separation of ownership and management. This is the most attractive feature of a company after limited liability. Limited liability is the most attractive feature of company. That means the directors can do their work freely. They need not worry about their personal liability unless they do some fraud. If you do a fraud, nobody will protect you. No law will protect you. That is something basic you should understand. Nobody will protect if you are committing a fraud. So talking about board of directors and shareholders, in LLP also we don't have this separation. In LLP we just call them as partners, but they have limited liability. So in this context, when I said one person company, you can have only one. So if you see here, in one person company, okay, in one person company, minimum member is one, maximum member is also one. You can't have more. But directors, minimum number of directors is one. Technically, you can have even 15 directors. See, practically, I have never seen a one person company which is having more than one director. But technically, it's possible for you to understand that one person company means one shareholder. It can be more than one director. It need not have only one director. One person company can have minimum one director, maximum 15. But members is minimum one and maximum is also one. Next, when we come to private limited company, you have minimum 2 members or 2 shareholders and maximum is 200 shareholders. Maximum you can have 200 shareholders in a private limited company. And in a private limited company, you should have minimum 2 directors and maximum 15 directors. If you want to have more than 15 also, you can pass a special resolution. That means more than 75% of your members, shareholders agree that we need more than 15 directors. You can have a special resolution. Okay, this is what is resolution is nothing but a decision in simple. Then you have a public limited company. So public limited company minimum is 7 members and maximum is unlimited. You can have how many members you want. Directors minimum we need to have 3, maximum 15. You can pass a special resolution and you can have more. Like that, we also have a concept of producer company, which is a company which is to help primary producers like farmers, weavers. All these people are unorganized and they get cheated a lot. So that is the reason why government came with the concept of producer company, where minimum directors is 5 directors. So 1% company is 1, private company is 2 directors minimum, and public company is 3 directors minimum, producer company is minimum 5 directors. So you need to know these numbers in general. Okay, great. Next, if we go further, Supreme Court of India has held that in the State Trading Corporation of India versus CTO, that company cannot have the status of a citizen under Constitution of India. So all this we need to understand, that company is a person. Yes, definitely company is a person, but company cannot be called as a citizen. Company cannot be called as a citizen. Company cannot go vote in the general election. So company is something which will never be able to vote. Company is something you need to understand, where voting is not possible for a company. Company can enter into contracts, company can do all of that, but not voting. And company is not a citizen. Company is having nationality. We can say Indian company, but we don't call it as a citizen of India. That is the first thing you should understand. Okay. So you have perpetual succession, corporate personality, capacity to sue and be sued, transfer of shares, and separate property. So these are the general features of a company which we should be aware. Okay, Companies Act provides for the kinds of companies that can be registered under the acts. The 3 basic types of companies which may be registered: private, public, 1% company. So this is what I have told you. Remember, even a 1% company is actually a private limited company, but it has a clause where minimum 1 member, maximum 1 member, minimum 1 director, maximum 15 directors. Are you understanding? If yes, please let me know in the comments if you are understanding or not. It should be something which you are understanding. I'm trying to put it in simple words, and we are trying to understand different business vehicles. To do business, you need a legal entity, and that legal entity can be sole proprietorship, partnership firm, limited liability partnership firm under LLP Act. So sole proprietor and partnership firm has unlimited liability, and that is something which many people don't want. So if you want limited liability, if you want to have a safe business, please go for a private limited company or a limited liability partnership firm. Limited liability partnership firm, as the name goes, you get limited liability. Okay, so this is something which you should understand. Great. So private company, public company, and 1% company are the broad 3 types of companies. And now you tell me, how many members can we have in a private limited? You can have minimum 2, maximum 200, and in a public limited, minimum 7, maximum unlimited members you can have in a public limited. Now, so section 3 of the Companies Act, along with the rules, company can be formed. So I told you, 7% for public company, 2% for private company, and 1% for a 1% company. These are the minimum number of members. What should they do? They should subscribe their name to the memorandum complying with the requirements of the Act. So what is that? We will try and understand. See, for every company, you have 2 main documents which we call as the memorandum. We call memorandum as the constitution of the company, and second is called as articles of association. We call article of association as the bylaws of the company. How do you run the company on a day-to-day basis? How do you run the company on a day-to-day basis? So this is what comes under the articles of association. So when I say constitution of the company, so this is a document, MOA, constitution of the company, and you have AOA. This is the second document which we have, AOA. So MOA, AOA, these are the 2 important documents Every company has. So in a partnership firm, it is a partnership deed. It is the deed which is the important document. In a LLP agreement is the most important document. So that governs who are you, what can you do, what you cannot do is in this partnership deed or LLP agreement. In company, you have two documents, MOA, AOA. Constitution of the company, what does it talk about? Name of the company. So your company is whatever, Infosys Technologies Limited. So that is your name. Infosys Technologies, what is your business, and Limited. Okay. Name. Then situation clause. Situation. So what is the situation? So situation clause is which state you are in. So in India we have different states. So in which state is this there? So that is the situation clause. So our company is in the state of Maharashtra, Karnataka, Tamil Nadu, Telangana, whatever. That is the name of the situation clause. Then the most important clause talks about the objects clause. Objects clause. So what is this objects clause? What business is the company into? What is the company doing? What the company is allowed to do? What do they want to do? So objects clause. We are a software company. We are a technology company. We are a manufacturing company. We are manufacturing solar panel. We are into food processing. We make let us say fast food, anything, but that is your objectives. We are an education company, that will come in the objectives. So after objectives you have something called as liability clause. So liability clause tells you, is your company having limited liability or unlimited liability or limited by guarantee? That means the owners of your company, what is their liability, means how much money should they pay, what is the maximum risk. So if it is limited by shares, so if you have invested 1000 rupees, your maximum liability is 1000 rupees. Even if company has a loss, you don't have more liability than that. Then we have the capital clause. So the capital clause talks about the authorized share capital of the company. Authorized share capital of the company. So it will be something like the authorized capital of the company is 10 lakh rupees divided into 1 lakh shares of rupees 10 each. So 10 lakh is my authorized capital. This 10 lakh I have 1 lakh share which I can issue to the public. If it's a private company, for private, or public company for public people, you can issue it and you can take money from them. That is the capital clause. Capital. So how many shares? The overall capital is 10 lakh, 1 lakh shares of 10 rupees each, or 10 lakh, 10,000 shares of rupees 100 each, whatever. And it need not be 10 lakh, it can be 1 crore, it can be 100 crore, it can be 500 crore, it can be just 1 lakh. Your authorized capital is the maximum capital which you can raise for the face value of each share. 10 rupees is the very common thing. You can have face value 1 rupee, you can have 5 rupees, you can have 20 rupees, you can have 100 rupees, you can have anything. But what is easy and what everybody does is, as a common practice, 10 rupees per share is the face value in general. You can even split that tomorrow. Today you can issue 10 rupees per share. You can make that 10 rupee share into 10 shares of 1 rupee each. We'll study that later in section 61 and 64 much later. Then we have the subscription clause. What is this subscription clause? People who agree to become members of the company and pay the money, they are subscribers. So this is what we call subscription clause. So we were studying now people who subscribe. So in a public company, minimum 7 people should subscribe. In private company, minimum 2 people. And in 1-person company, minimum and maximum is 1 person should subscribe to the memorandum and articles. Both they should subscribe, saying that we are agreeing to become members, we are going to pay the money. So minimum you need these many people as per section 3 which we studied in Companies Act 2013. Then we have articles of association. So articles of association, you can refer table F of the Schedule 1 of Companies Act 2013. 2013 Schedule 1 Table F talks about Articles of Association. So what does it talk about Articles of Association? It tells you what are all the things which is required. For example, meetings, accounts, share issue, bonus share, correct, and secrecy, audit. So whatever a company can do, those conditions will come under the Articles of Association. The first directors of the company, all these clauses. So you'll have 80, 90 clauses, which is like how you run the company. So if you are a company secretary, if you are a director of a company, if you are anyone into the management of the company of the day-to-day affairs, the first document you should see is actually Articles of Association. Then you see the memorandum. What you can do, what you cannot do, how you can do is mentioned in your Articles of Association. And if you don't like it, or if you don't have the permission as per your articles, if you don't have permission, you have to amend. You have to amend your Articles of Association and get the permission to do it. So this is the very basics of how a company works. So just to explain to you this word subscribing, I went to memorandum, articles, what are the clauses, and this is how it is going to be. All our classes at Ekcel Academy will ensure that you get to the bottom of every concept and every topic. So this is the subscribing the name to a memorandum and complying with the requirements of the act in respect of the registration. So this is what is the basic you should understand. So company may be formed. How can you form a company? The first thing is you can form a company limited by shares, limited by guarantee, unlimited company, which really I don't know. In fact, India does have. Even recently when I saw, I was surprised. India, we have around 15 to 16 lakh companies. In that, we have around 295, I think, if I remember properly. 295 companies are registered as unlimited company. I really don't understand why. Because the very word company is people want limited liability. If you want unlimited liability, go for proprietorship concern, go for partnership firm. Why do you want a company and extra compliance, extra rules? It's very obvious. You go to a company because you want limited liability. So I don't know who are these 295 companies, or did they get registered by mistake? We don't know. But there are 295 companies which are unlimited companies in India. That means the limited liability of the members is not there. So the members may have put only 1000 rupees. Okay, but their liability can even be 1 crore if there is a loss to company, because it is unlimited company. Tell me, if you are a shareholder, you'll say, what is this nonsense? I don't want this company. So nobody does this. Today in India, 99.99% of all companies are company limited by shares. Okay. Company limited by guarantee is another concept where it's rare, but it is there. It is rare, but we do have that concept, and that is you agree to a certain sum of money which you will give at the time of closing of the company. So you're guaranteeing that. That is anyway not very relevant in today's scenario. Today, every company that I know is a limited by shares, and that is the default way. So for theory you can study all this, but for practical reasons it really doesn't make any sense. Okay, so you have statutory company, registered company, and unregistered company. So unregistered company, again, hardly very relevant for us. In registered company, limited by shares, limited by guarantee, and unlimited company. Statutory company is nothing but like there is a separate act, LIC Act under Parliament of India, SBI Act. So these are statutory companies which having a separate act for itself, and best example is LIC, and they are very few and far between. When I say registered company, company which is registered under Companies Act 2013 or previous company law. Companies Act 2013 is the present law. So any company registered there is called as a registered company for our reference. So classification of companies based on incorporation. So incorporation, I told you, statutory company. You have Reserve Bank of India, Life Insurance Corporation, etc. These are all statutory companies where the government has enacted a separate law. You can't do that for all. You can't, and that is only for government companies and where it is strategic and where it is very important you have it. Otherwise, it really doesn't make any sense. Registered companies, the next important thing, which is 99.9% of all companies in India are registered companies. That means they are registered under Companies Act or previous company law. So what is this previous company law? So before 2013 Act, we had Companies Act 1956, Companies Act 1913. So for example, a company like Tata would have been registered under 1913 Act because it's more than 100-year-old company. So obviously they registered there. Yes, Tata has different companies. It's not like one company. Brand name is Tata. You have hundreds of companies within Tata. But the original company would have been registered under 1913. Almost every other Tata company would be registered under 1956 Act. But today they have to follow 2013 Act. So a registered company is a company which is registered under this new act or the older acts which are there in India. Yes, because 2013 is just 10 years old. So 10 years ago, not most of the older companies were registered under 1956 Act. Okay, great. So classification on based on liability, I think I told you, unlimited companies, company limited by guarantee and company limited by shares. So this is the most common. So company limited by shares, company having liability of members limited to the memorandum. So what amount they have given in the memorandum, that is their thing. For example, shareholder has paid 85 rupees on a share. Okay, shareholder has paid 85 rupees on share, face value of rupees 100, and the maximum shareholder has to pay is rupees 15. So you have to pay 100, but he has paid only 85. So company can ask another 15 rupees, not more than that. So liability is only your unpaid capital, nothing more than that. You cannot ask more than that because it is a company limited by shares. Whatever shareholder agreed, that is the subscriber agreed to pay, you can ask that much money. You can't ask them more money. So they told they agreed to pay 100 rupees and they have paid only 85. You can ask them 15. You can't ask them give me another 40 rupees, give me another 60 rupees. You can't ask because it is a company limited by shares. You just can't ask, and it is as simple as that. Okay, so this is broadly speaking which we understood: one person company, private company, public company, broadly speaking. So I told you minimum one member, one director, minimum 2 members, maximum 200 members, minimum 1 director, maximum 15 directors, minimum 7 members, maximum infinity, unlimited number of members, minimum 3 directors, maximum 15 directors. You can have more than 15 if you want to pass a special resolution. You can have more than 15 also. It is possible. It is possible. Okay. Listed company. So listed company is nothing but a public company which has registered and listed the securities. It could be shares, it could be bonds, it could be debenture, which is listed on a recognized stock exchange. So any sort of security, any type of security which we have studied. So to security, you should go to section 2, subsection H of Securities Contract Regulation Act. So this is your act. So according to this act, you have share, scrip, bond, debenture. Shares is the most common type of security. Again, we have equity shares and we have preference shares. So any security can be listed on the stock exchange. Great. Okay. I hope you are understanding. Next important we need to understand is small company. You tell sir, what is this small company? It is a type of classification. It is not like public company, private company, small company. It's not like that. It is a type of classification. First of all, public company cannot be small. That is the first thing you should understand. Public company cannot be small, and any company which is having 4 crore as your paid up capital, 40 crores as your turnover. So if it is up to 4 crore and up to 40 crore, up to 4 crore and up to 40 crore, it is a small company. Just to ensure that more and more people should open companies, government has done that. So in small companies, I'll tell you what happens. See, when you have a classification as a small company, your paid up capital and your turnover. Paid up capital 4 crores. It's a lot of money. Most companies will not have 4 crores. Turnover 40 crores. Again, most companies, if India has 15 lakh companies, most of them will not have a 40 crore turnover. So if you have below this, you will be called as a small company, and above this, citizen other companies or normal companies. So what they have done is, in terms of compliance, you have more. Compliance is more in other companies. So when I say small company, there will be many sole proprietorship concern, many partnership firm, even many LLP who will be having less than 4 crore capital and less than 40 crore turnover. So government wants to encourage, the government of India wants to encourage more people to start a company and tell them that, see, just because you're a company, don't think you have to follow hundreds of rules and it is so difficult for you to run the show. We are giving you an option that even if you are a company under Companies Act, still we are going to give you option where you will have very few compliances compared to others. So for example, in Companies Act 2013, we have 470 sections and you have hundreds of rules. Small company need not follow most of this 470 section. There is a list what applies, what doesn't apply. We'll go to that in the relevant chapter, but you need to understand that they don't have to. So it is like encouraging them to start a company, and this is a very good move to help more and more businesses to register as companies in India. So this is what is small. So what is small company? It is a classification. It is not a type of company. It is a classification of a company. So first thing you should understand, public company cannot be small. That means it is only private company which is having less than 4 crore turnover, which is having less than 40 crore for 4 crore capital and 40 crore turnover. 4 crore capital and 40 crore turnover. Okay, turnover which is does not exceed 40 crore. I already told you this. Okay. Nothing in this clause shall apply to holding company or subsidiary company, company registered under section 8, company or body corporate governed by any special act. So for such people, small company will not apply. Next important thing which we study is called as a private limited company. So what is a private limited company? So first thing is articles. So this is what many people get confused. So I want to make that very, very clear. So I told you the most important document for a company is the book which we call as Articles of Association. It has all the bylaws, all the do's and don'ts of a company. Correct? Articles of Association has all of this. Now, how will I know some company is private or not? So, the articles should tell. The articles is the main document. Articles should tell whether that company is private or not. So, any company where the Articles of Association has a restriction on transfer of shares, limitation members, 200 is the limitation, limit the members to 200, restriction on transferability of shares, and prohibit, it is not allowed in a company, it is prohibited to do what? It is prohibited to issue securities to public, that is all your share, securities, everything. Restriction on transfer of shares, prohibition, issue of securities to the public. So this is the concept. So this is the concept which we need to understand, where all these restrictions are there. And all these restrictions are given in the Articles of Association, which is what you have to understand. Section 2, subsection 68. Private company means a company which by its articles. So this is one thing which students forget. The most important word here is articles. So simply you will by heart. What? Restrict the right to transfer of the shares. Limit the member to 200. But the reality is, you should know where do we have this restriction, where do we have this limitation, where is it written, and that is written in nothing but the Articles of Association of the company. So the Articles of Association of the company gives you a clear restriction on the right to transfer the shares, correct? And it has a restriction on the number of members to 200. You can't have more than that. Yes. 200 members, and also person or an employment of the company. So if somebody is an employment of the company and is also a shareholder, we don't count them to calculate the number of 200. So if somebody is employee of the company and also shareholder of the same company, to calculate that 200 we don't count. So that means even if more than 200 are there, let us say there are 200 members and there are 2 employees who are also members. So technically there are 202 people, but practically as per the Companies Act, we don't count the 2 people for counting 200. They are shareholders, they get all the benefit of shareholders, but we don't count them for that 200. So for that some student ask, sir, what if company has 800 employees, all of them are employees and have shareholders share in the company, can we have it? And there are another 200 people who are already members. So if you look at the Companies Act, you can, because they say 200 members plus employees who are members are not counted for 200. They are counted for everything else, but for counting that they are not there. So technically you can have, for counting it is only 200, but practically you have 1000 people. Again, this is very exam oriented and just hypothetical. In real life it never happens. Let me tell you, in India 99% of private companies in India have 10 to maximum 15 shareholders. That's all. In that also maximum are below 10. Only nowadays new startups, even there it is like 30-40 people, not more than that. Even I'm telling about big funded startups where thousands of crores have gone. You have 30-40 shareholders, you have the investor, you have some other company investing. It will not be more than that. So whatever we study here, it is for exam. In reality, I have never seen a private company with more than 100, 200, never. The maximum I've seen is like some 30 shareholders or 30 to 40 shareholders in even a very big private company. Like we have done a work for a very big startup. there also it was like some 27, 28 shareholders, including all the foreign investors who had invested 100 crore, 200 crore. Still it was only that much. Okay. So that is what you have to understand. Persons who have been formally in the employment of the company were members of the company while that employment have been continued to be members. So if somebody was a member of a company and employee of the company, suppose he left his employment, he resigned and left his employment, but he did not sell his shares, he continues to hold the share. Even that person, we don't count them to calculate the number of 200. So that is what you have to understand. Then the next thing I told, prohibit the invitation to public to subscribe for securities of the company. So for a private company, you can't openly tell, come and buy our share, come and buy our security, like you tell in public company. In public company, you can have a open offer to the public. In private company, the maximum you can do is private placement. That is, to select group of people, you can issue shares, but you can't make a public offering. Only a number of members that is limited to 200 is maximum you can have. Private company can issue debentures to any number of persons. The only condition being that invitation to public is prohibited. So technically you can issue debentures even to 2000 people, but practically it is not possible because that is not how it works. Technically, private company can issue debenture even for 10,000 people, but you can't make a public offer. It has to be private. It has to be through your connects, to your contacts, to your friends, family, business network. You can't advertise it publicly. That is prohibited as per the articles of a private company, as per section 2, subsection 68 of Companies Act. Okay. All right. Then, yeah, so we already did this. Who are the private companies? It's repeating. Yeah. Examples, you have many. Flipkart India Private Limited, Ola Automatic Exchange Private Limited, Carrot Lane Trading Private Limited, Zomato Foods. Now Zomato has become public, but yeah, Make My Trip India Private Limited. So these are all companies which started as private limited, they did. Later, they became public limited wherever required. Now, what is a public company? What is a public company? It is exactly the opposite. So let us try and understand a public company. So in private company, what did we say? You will have limit on the members, that is to 200. Then you will have restriction on transfer of shares. Then you will have prohibition. And where will all these three things be written? Articles of association of your company. You have all these three: limitation, restriction, prohibition. In a public company, it's very simple. In public company, what is it? No limitation. You can have how many ever people, infinite number of members, shareholders. No restriction on transfer of shares. Share transfer is freely possible. That we call as freely transferable. There are no restrictions. It's very easy to transfer shares if you're a public limited company. Next, prohibition. No prohibition to invite. Prohibition to invite public. Prohibition to invite public to subscribe. Prohibition to invite public to subscribe to shares or securities. So in a public company, you don't have prohibition, no prohibition. You can invite the public. You can have an advertisement, you can have newspaper ad, you can have a TV ad, you can tell, come buy shares of our company. That is allowed as per the provisions of public limited company. So very simple, whatever you study in private limited, opposite that is public limited. It is no restrictions at all. So you should have minimum 7 members and you should not have any other restrictions. You can continue it. And most of the provisions of public limited is not easy to comply. In fact, we have a client, it is a public limited company. Now they're converting to a private limited company because they feel that we don't have such big operations. We are not taking money from public. We really don't want to have so much strict compliance. We are happy to be a private company and run the business, and you can do everything. In India, even a company like Google, in India it is private limited. In US, obviously Google is listed, Apple is listed, but in India these are all, including Intel, all these big companies of US, in India they are all private limited because they don't need money, they have money. Companies which need lot of public money go to the stock market and raise the money, which we call as capital markets, to raise money. But otherwise you don't need money, so you will not require it at all. Securities or other interest any member in a public company shall freely be transferable. This is what I told you. You can transfer shares without any restrictions, which is the easiest and best part. Public and private companies, we have a Western Maharashtra. This is a case. Okay. There is a difference between transferability of shares relating to private and public companies. So private and public are different. Private company is restrict the right to transfer. In case of public company, the act provides that shares debentures shall be freely transferable. So we have a case law also which tells clearly that it is freely transferable. You have a lot of freedom to transfer the shares. So you have different examples of, there are thousands. You should just get a picture. Okay. So I think I have also shown you, we have about, in India, there are about, in India, we have about 70,000 public companies. In that, about 6,000 are listed public companies. So we have a long way to go. Listed company. So this is a long way to go. So in 70,000 companies, all are public. 70,000 companies, all are public limited companies. That means in India, 95% companies are private limited companies. 95% are private limited companies. It's easier to run a private limited company. You have much more rules and regulations for a listed and public company. Listed, you have extra because all the SEBI related provisions also come into picture. Okay. Okay. 1% company, I think we discussed. So government wanted more and more proprietors to start and have a company, and that is why the 1% company concept came into picture. So 1% company, the memorandum is of 1% minimum and 1% maximum, and it is a type of private company. This is the basics which we need to understand. Okay, this is everything about 1% company. 1% company, all these provisions are there. Okay. Next, briefly I'll tell you about Nidhi company, which is applicable only to India. It is applicable only to India. It is there only in India. Nidhi company is where we are accepting deposits and lending money to the members only. So it's a very ancient Indian concept where we have the members. Let's say we have 200 members, and these 200 members lend between themselves. It is not a chit fund. Chit fund is different. You have separate chit fund act. The rules are different for a chit fund. Nidhi company is where it is a company under Companies Act. There are very few, but they are there. So there will be maximum 100 or lesser than that in entire India, but you should know what it is. So principles of mutual benefit has been incorporated to pool the savings from members and lend only to members and they are prohibited from having dealing with non-members. You can't have any dealing with non-members. You should have only the members, and that is the only way to take it forward. And that is what we understand in Nidhi company. And Nidhi companies are very few and far between, but you do have Nidhi companies in India, and you should have a brief picture about Nidhi companies. See, Nidhi companies not permitted to engage themselves in chit fund. You can't do chit fund. You can't do hire purchase, insurance, or any other business, including investment in shares or debenture. You can't do. So there are a lot of restrictions. Nidhi company do business only with their members. See, bank does business with everybody, general public, but Nidhi company is not like that. Only their members can do business. So members are only individuals. Body corporates, trusts are not admitted. See, in a normal private company, public company, one company, one LLP can be shareholder of another company. But in Nidhi company, only human beings, only natural persons. So it's not very, very attractive, but you do have Nidhi company, and these are the basics of Nidhi company which you need to understand. So in general, you need to get the basics here. For a business entity, we are talking about business entity. So we have sole proprietorship concern, partnership firm, LLP. These are the business entities which many people do. And then we have company. In that we have 1% company, private company, public company. Then you have producer company, primary producer like farmers. Then you have Nidhi company. Then you have something called as charitable or section 8 company, charitable company, which is for the benefit of society to promote art, science, culture, sports, rural education, slum development. All these kind of things can be a charitable company. So they are not having any financial profit, they work for social profit, and that is what we have in section 8 company. So these are the broad based things which we need to understand relating to all these type of companies. And this is just an introduction. Like this we have many more interesting concepts, so we can get into all of them. So if you are interested to know more, please do get in touch with us, and you can always get in touch with us on our number 973 973 3400. So I will come back with more such classes. Thank you very much, and I will see you in the next one. Thank you.